Good afternoon and welcome to today's webinar, Marijuana Rescheduling and Oral Fluid Testing, What Employers Should Know. I'm Jessica Polk of the Current Consulting Group, and I'd like to welcome you to our presentation today. Today's presentation is sponsored by Abbott. At Abbott, they create life-changing technologies and products that help people live healthier, fuller lives. With a proven history under the established eScreen brand, Abbott is your trusted partner to deliver substance abuse testing and occupational health services that help you achieve a safe, healthy, and productive workplace. Today's presentation has been pre-approved for continuing education from HRCI and from SHRM for those who attend the entire live presentation, and we will email you those IDs after the presentation to those who qualify. Today we have with us two presenters. We have with us Bill Current of the Current Consulting Group and Brian Feely, also of the Current Consulting Group. Bill founded Current Consulting in 1998 and has held several leadership positions throughout his career, including Vice President of Consulting at Employee Information Services, Executive Director of the American Council for Drug Education, and Director of the Institute of a Drug-Free Workplace. He is the author of 11 books on substance abuse prevention and drug testing, including his 2026 release of What Every Employer Should Know About Marijuana, which is available on Amazon. Bill is also, he serves as the board of directors at Indesa and the board of trustees of the Indesa Foundation. Brian is the Senior Vice President at Current Consulting Group. He has more than 40 years of experience in the medical diagnostic industry. He is named as an inventor on 4 patents in the diagnostic field and is an author of numerous publications and speaks frequently at industry meetings and workshops. He is considered an expert in the science and business of drug and alcohol testing products with a particular focus on the merits of oral fluid drug testing. Brian is also well versed in compliance services such as drug testing policy, training for supervisors and employees, and state and federal law issues. And so, with that, I'll go ahead and turn the virtual microphone over to Bill.
Thank you, Jessica, and welcome everyone to today's webinar presentation. As you can see, here's the agenda. We're going to cover a lot of information today. But before we do, I just want to give a shout out to Abbott, thank them for sponsoring today's webinar presentation. I think as many of you may know, the Current Consulting Group does a survey of the drug testing industry every year. In fact, we released the results of our 28th annual drug testing industry survey earlier this year at the Indesa conference. And as part of that survey, we do what we call a brand name recognition survey. And it's divided by different categories: lab-based urine testing, lab-based oral fluid testing, point of collection, urine testing, etc. And Abbott always scores among the leaders in most of the categories. In fact, as I was telling them recently, they even score in categories that they don't provide services in because their brand is so strong, it sort of bleeds into other areas. But Abbott is really one of the iconic brands in our industry, and we're very grateful for their support of this webinar today, and welcome you to just ask them any questions about the services that they provide. I'm sure that they would be happy to get you in touch with somebody who can answer those questions. So we're going to talk about marijuana rescheduling. That's just such a hot topic right now. And there's so many questions that are still unanswered. We're going to try to answer as many as we can, but it is a constantly evolving issue, and we're really not sure entirely what's going to happen because there are a lot of lawsuits, active lawsuits, trying to slow down or eliminate the rescheduling. I'm not sure they're going to be successful. We'll talk about those in a minute. We'll also talk about why employers should continue testing for marijuana, which is a series of questions we include in our surveys. And then we'll talk about current trends in workplace marijuana testing, and then oral fluid drug testing in a sort of post-rescheduling environment. And I'll take the first part of today's presentation, and then Brian will come in and speak to the rest of it. He has a wealth of experience, decades of experience with oral fluid testing, so he's the perfect person to address those issues. And then we'll leave you some room for questions and answers at the end, as well as some poll questions that we're going to insert at different points in today's presentation. So let's get started with marijuana rescheduling, what it means and what it doesn't mean for employers. And just sort of as a primer, drugs get scheduled. They get scheduled as part of the Controlled Substances Act. And there are 5 different classifications of drugs or substances. Now, not everything ends up being in one of those 5 scheduled categories, okay? But the drugs with the highest potential for abuse and no known medical use are usually Schedule 1 drugs. And I'm going to take you through all of them here in a second. But those are the most dangerous drugs. And so you see heroin, for example, marijuana, amphetamines, etc. Those are in that category. Now, if you look at Schedule 1 compared to Schedule 2, these are still these are both categories of drugs that can be very dangerous. And you want to be very careful if you're, prescribed anything that has fentanyl in it or oxycodone, etc. But there's a difference between Schedule 1 and Schedule 2 drugs, but they're pretty serious. These are serious substances, right? As I mentioned before, in Schedule 1 you have heroin, LSD, marijuana. I mentioned amphetamine before, but you see the long name there for ecstasy, really, methaqualone, peyote. And those are Schedule 1 drugs compared to Schedule 2, where you find cocaine or oxycodone or fentanyl. In Schedule 3, which is the schedule that we're all learning about more, you find substances with what they refer to as moderate to low potential for physical and psychological dependence. Okay, so these are different types of drugs. You see ketamine on the list, anabolic steroids, but look at also these are products that contain less than 90 milligrams of codeine per dosage, like Tylenol with codeine. In my mind, I don't really equate marijuana with Tylenol with codeine, but that's where marijuana will be if it is fully and successfully rescheduled. And then you see Schedule 4 drugs, Schedule 5 drugs, a lot of those like Robitussin AC are drugs that we're very familiar with. Schedule 4, Xanax, Darvin, Ambien, Tramadol. So those are the 5 categories of scheduling in the Controlled Substances Act. Now, a lot of people had no idea how a drug gets scheduled. And so it's really involves 2 federal agencies, the DEA and the FDA, the Drug Enforcement Administration and the Food and Drug Administration. So what happens is a petition is started, and the process can start with the DEA, or it can be a petition from an outside party, like a drug manufacturer, for example, or as it shows here, a medical association. And HHS, FDA, Scientific Medical Review then gets involved, and they look at the drug, and it's a very involved process. It can take a long time, but then they make a recommendation on the scientific and medical matters involving that drug. They make that recommendation to the DEA, and the DEA makes the determination whether a drug will be scheduled, and if so, in what category. But they typically make the final decision. Now look at that last bullet. This process can be slow, it can be contentious at times, it can take decades, as it has with the rescheduling of marijuana. As you know, marijuana has been legalized for medical use in many states, but that has been done outside of the federal purview. So even though a state may have legalized marijuana for medicinal purposes, it doesn't mean that it's an FDA cleared drug or FDA approved drug. Okay. But that process with marijuana has taken a long, long time to get to the point where we're at right now. This all kind of started during the Biden administration, where there was a movement toward looking at marijuana to see if it should be rescheduled. So it started back in those days. And then in December of last year, the Trump administration directed the Attorney General to expedite rescheduling and to make it happen. So an executive order was signed. And then the interim Attorney General signed an order back in April of this year to begin this process, to move forward with the rescheduling of marijuana. And this would essentially, as you saw from the 5 different categories of scheduling, this would downgrade marijuana to Schedule 3. So it puts it in a category of less dangerous drugs that are less prone to abuse or dependence, and also that has medical purpose. It would make it possible, if marijuana products were ever approved by the FDA for the drug to be prescribed by doctors. Whereas right now, it can only be recommended by a doctor in a state where medical marijuana has been approved. So it's a little bit of a kind of a tricky category there. And you have to keep in mind also that there has been some uncertainty with this whole issue of rescheduling as to whether or not the Department of Transportation, DOT, would still have the authority to require covered employers in transportation safety sensitive industries to test for marijuana, either for pre-employment or for post-hire. And so there's been a push during this rescheduling process for something called a safety carve out. Many companies in the industry and NDASA itself have been very involved in trying to lobby for the inclusion of safety carve out language and any rescheduling verbiage that actually gets approved. As I mentioned before, there are a lot of lawsuits. They continue to be filed and they have various purposes, but the idea is to either halt or maybe get Congress involved somehow in the process. And some members of Congress have been very vocal about their opposition to rescheduling. And so that's an ongoing side issue that may or may not have any bearing on what actually ends up happening. It's important to know also that marijuana rescheduling, moving it from Schedule 1 to Schedule 3, does not mean federal legalization of marijuana. Okay? It doesn't make marijuana legal on the federal level. Right now, it's still illegal. But rescheduling does not prohibit employers from testing for marijuana. So even if it is rescheduled, it doesn't mean employers lose the right or the authority to test for marijuana. They can, but we don't know exactly how it's going to be affected yet. I think you'll find in today's presentation there's lots of justification, even under rescheduling, to continue testing for marijuana. We also don't know the whole situation with DOT and how that's going to shake out. DOT has some opinions on that, though. They issued a statement on May 15th, essentially clarifying some confusion that this whole issue of rescheduling has caused. For example, this is from their memo from May 15th. Marijuana rescheduling does not change DOT drug testing requirements. MROs cannot verify a laboratory confirmed marijuana positive as negative based on an employee's use of state licensed medical marijuana. And then this third bullet's critical. State issued medical marijuana cards, physician recommendations, and dispensary records do not qualify as a legitimate medical explanation under the DOT regulations. Why? Because state dispensed marijuana is not an FDA approved prescription drug. So that's what an MRO would normally be looking for. Some type of legitimate prescription for whatever drug may have triggered a positive that could possibly be overturned and changed to a negative. What DOT is saying here is that marijuana rescheduling does not change DOT's authority to require testing for marijuana at this time, and that MROs cannot accept a use of a state licensed medical marijuana product as justification to overturn a laboratory confirmed marijuana positive. That's good information to have, because as we go forward, employers are still wondering, what's this mean for us? What are our rights in this situation? And to simplify it to the most basic terms, employers still have the right, even under rescheduling, to prohibit employees from bringing marijuana into the workplace, using marijuana while on the job, or being at work under the influence of or impaired by marijuana. We're going to get into the whole impairment issue here in a few slides, but it's important to understand that employers are not required to let people use marijuana at work or be under the influence of marijuana while they're at work. But as to testing for marijuana, that hasn't changed yet. I don't know if it will change under rescheduling, but then we have to talk about state drug testing laws and state marijuana laws, because those definitely come into effect as employers test for marijuana. So in summary, the president's executive order does not legalize marijuana on the federal level. Marijuana has not been reclassified from Schedule 1 to Schedule 3 yet. That change is pending, but it's in motion. And DOT has been very clear that they still require covered employers to test for marijuana, and that if you're going to test for marijuana outside of DOT, then you have to be aware of the state drug testing laws and the marijuana laws that come into effect. Some of those state laws would be affected by rescheduling, and that we would just have to cover for you on a state by state basis. Okay. That's the summary of the first part, just to sort of set the stage for what we're going to talk about today. But I mentioned that we're going to do a series of poll questions to get you in on the action here participating. So Jessica, let me turn it over to you to go to our first poll question.
Great. Thank you so much, Bill. So here we go. If you'd like to help participate in these polls, we always appreciate your feedback. So, what best describes your organization's current approach to marijuana testing? I'm going to launch this poll for you so you can participate. Your options are: we continue testing for marijuana in all situations, we test only for certain positions, safety sensitive, for example, we have reduced or eliminated marijuana testing, and we are currently reviewing our policy. So it is now open for you to participate. We look forward to your responses. Okay, we're going to share the results now. And so we see that 67% of you said that we continue testing for marijuana in all situations. 17% we test only for certain positions. 14% said we have reduced or eliminated marijuana testing, and 2% are currently reviewing their policy. So I'll close this and send it back to you, Bill.
Okay, that's really interesting because even though 67% say they continue testing for marijuana at this time in all situations, you know, 10 years ago if we'd asked that question as a poll in a presentation, it would have been, 90%, 95%, whatever, it would have been a much higher percentage. So we are seeing some erosion there in the percentage of employers that are testing for marijuana in all situations. And then 14 of you said that you've already reduced or eliminated marijuana testing. We're seeing that number sort of level off. That started to go up about 5 years ago, 4 years ago. And then in our surveys that we conduct, we've seen that number level off. So I'm not surprised at the 14%, but it's really sort of what it's been the last couple of years. So now let's get into the next section, which was why employers should continue testing for marijuana. And we're going to use information from some of our current consulting group surveys. So in our 2025 survey of employers, we do two surveys, one of the industry, which we do in the spring. The 2026 survey is out. It's at our website at currentconsultinggroup.com. It's also available from Abbott. They were one of the co-sponsors of the survey, so you can get it from either one of us. The 2025 employer survey comes out in the fall, so that won't come out for a few more months, but you can still access the 2025 survey results at our website. And we asked, why establish and maintain a drug testing program? 78% of employers said to promote a safe workplace. And skipping down to the fourth bullet, 44% said to hire the best possible job candidates. And then we asked the question, what benefits does your company realize from drug testing? And 84% said it improves safety in the workplace, the number one response. And 62% said it enabled them to hire better quality employees. So why do it? To promote safety, to hire the best possible job candidates. What are you getting out of it? It helps to improve safety in the workplace and enables us to hire the best quality employees. So to me, that says drug testing works. It's fulfilling its primary purposes. Now, there was a survey done by the National Safety Council on impairment. I'm not going to go through every one of these bullets here, but it was really interesting. It was a survey of employers, and 52% said that impairment is decreasing the safety of their workforce. Now, I'm going to share some information in a maybe on the next slide or two about the connection between marijuana use and impairment on the job. But 52% in that NSC survey said that impairment is decreasing the safety of their workforce. 43% said it has increased or contributed to an increase in workers' compensation claims. So more accidents, more workers' compensation claims. You see the fourth bullet, 39% say impairment is causing more injuries. So not what we want to see, but as marijuana use has gone up, there's definitely been a connection or a correlation with an increase in post-accident positivity for marijuana, which also coincides with an increase in workplace accidents and workers' compensation claims being filed. Now, are employees using marijuana while on the job? Well, yeah. In one survey, 1 in 5 said they've used marijuana recreationally, not for medical purposes, in the workplace during work hours. And in our survey, when we asked, would discontinuing marijuana testing lead to employees using marijuana on the way to work, 59% said yes, they believe that's true. And then there was a really interesting survey of 1,000 admitted drug users who were employees. 28% admitted to getting high on the way to work. 22% said admitted to getting high while on their lunch break. 11% get high in the afternoon, but while still at work. 10% said they get high in the morning while at work. And I thought it was also interesting that after getting high all day long, 5% say they get high on their way home. Well, this is important. This is an important issue to be aware of and something that should be covered in your company policy. Now, the company policy deals with drug testing issues, when testing will occur, how testing will be conducted, etc. But it should very clearly articulate what type of behavior is prohibited and what may result in a violation of the company policy. For example, a prohibited, second bullet there, a prohibited action may be to have drugs in their system as evidenced by a positive drug test result. We're not claiming that the drug test result proves impairment, but we're saying that the presence of drugs in an individual's system, as evidenced by a positive drug test result, can be considered a violation of the company policy. Keep that in mind because the fourth bullet down, we're going to talk about oral fluid testing in some detail when Brian comes on, but it's important to know that with oral fluid testing, you're detecting the parent drug or the drug itself versus urine testing, where you're basically detecting a metabolite of the drug, which takes some hours to become detectable in a urine sample. So we'll come back to this, a lot more on that in a second. But in addition to a positive drug test result, especially in this age of marijuana, or I should say legal marijuana, but also in an age where some states have passed laws that require employers to have some other evidence of impairment in addition to a positive drug test result before they can take adverse employment action. So that's why supervisor training is so important on the signs and symptoms of possible substance abuse and documenting such things as reckless behavior or employees neglecting safety protocols or them being able to perform their job duties correctly or safely, and a whole bunch of other issues that may be used if they're documented properly in combination with the drug test result to be able to take whatever appropriate action a company feels is necessary under the circumstances. Now, when you think about individuals using marijuana while on their way to work, it's important to understand that there are state laws that prohibit employers from discriminating against individuals who are what they call doing lawful things on their own time, such as in a state that's legalized marijuana, using marijuana on their own time. Well, one could argue, probably successfully, excuse me, that while you're driving to work in the morning, that's your own time, right? And so an employer shouldn't be able to discriminate against an employee who smokes a couple of joints on his commute to work in the morning. But there was a study done in 2021 of 80 different studies from around the world, and it came to the conclusion that the impairment window, or the window of impairment for cannabis, is somewhere between 3 and 10 hours. May last up to 10 hours if high doses of THC are consumed orally. Now, keep in mind that impairment is affected by many different things. How the drug is used, how much of the drug is used, the drug history of the person using the drug, and very importantly, the tasks or job responsibilities that are being performed by that worker. So, for example, as you see in that, what is it, 1, 2, 3, fourth bullet down, impairment may extend up to 6 or 7 hours if higher doses of THC are inhaled and complex tasks such as driving are required or assessed. So if you're in a safety sensitive industry and you have employees doing safety sensitive jobs and they're getting high on their way to work in the morning, they could very well still be under the influence, if not impaired by marijuana, while on the job, even though they consume the marijuana on their own time. Now, on this issue, again, we're not saying that a drug test is proof of impairment, but there are a lot of state laws that are starting to include impairment anti-discrimination language in their legal marijuana bills, or I should say legal marijuana laws. But here's a couple of examples of legislation. Excuse me, fighting a little bit of a summer cold here in South Florida. But here are a couple of examples of current progressing legislation that, if enacted, would limit employers' ability to take adverse employment action absent some evidence of impairment, as you see in Massachusetts and also in New Jersey. So the takeaway from all of this is that employers must be prepared to demonstrate impairment and not merely or solely rely on a positive drug test result. Now, this slide I'm not going to spend a lot of time on because Brian's going to speak in detail to the oral fluid issue. But oral fluid drug testing is becoming really popular now and growing in popularity according to our industry survey and our employer survey, in part because it aligns well with this whole issue of impairment in the workplace. And again, I'm not saying oral fluid testing proves impairment, but in situations where you want a tighter window of detection, you don't want to go back several days of detection or even weeks or months with hair testing, but you want a tighter window of detection, or somebody comes back from their lunch break smelling of marijuana. Maybe they were out in their car eating their lunch and smoking a couple of joints. It might trigger a reasonable suspicion test. And in that situation, you would want a test method that can detect very recent usage within minutes after usage. And that's what you get with oral fluid because it's detecting the parent drug and not simply the metabolite of cannabis. And this is just another emphasis on the importance of your policy, and that in your policy, you state very clearly that employees will be held accountable if they bring marijuana to work, if they're caught using marijuana while on the job, and if they're impaired or under the influence of marijuana while working. Your policy is critical, okay? It should be reviewed and updated at least annually, because there are, this year, for example, alone, there are over 500 bills at the state level that, if enacted, would have an effect, a direct effect on workplace drug testing. And some of them are marijuana laws. Now, we don't know how rescheduling is going to impact those laws. I think there will be an effect. But again, keep in mind, rescheduling of marijuana from Schedule 1 to Schedule 3 does not mean that the federal government has legalized marijuana. Keep a close eye on that for the time being, but make sure your policy is up to date and reflects the latest changes to any state laws that apply to you. When I get asked, we're in multiple states, which state law applies to us? The answer is always all of them. Your policy has to be customized to take into account all the different laws that apply to you. So we're at the end of section 2. Let me turn it back over to Jessica for our second poll question.
Thank you so much, Bill. All right, our next question is, what is the biggest factor influencing your organization's marijuana testing policy today? So changing state laws, hiring and retention challenges, workplace safety concerns, uncertainty about future federal regulation. So we're launching that and share the results. We have 28% said that changing state laws is the biggest factor influencing their organization's marijuana testing policy today. 13% said hiring and retention challenges. 41% said workplace safety concerns, and 18% said uncertainty about future federal regulations. All right, back to you, Bill.
Okay, thank you, Jessica. And that really aligns with the results from our current consulting group survey earlier that I shared, which was safety concerns being the number one response. And as I mentioned the surveys, let me share a few slides from our survey that speaks to trends. And this comes from our 2026 industry survey. So when we asked the question, what percentage of your clients have dropped marijuana from their drug test panel in the last 12 months? 20% said more than 10% of their clients have dropped marijuana. 57% said between 1 and 10%, and 23% said none of their clients have dropped marijuana. And then in that light blue box, you can see how it compares. So this kind of aligns, with what we saw in that earlier poll question that we did, where we asked the question, how many of you have reduced or eliminated testing for marijuana? You said 14%. And so this doesn't, this is not apples to apples in terms of the percentages, but you can see it's a pretty high percent. 20% of people in the industry say that more than 10% of their clients have dropped marijuana from their drug test panel in the last 12 months. Now, when we ask the question, do you believe more clients will drop marijuana in the next 12 months? 58% said yes, 23% said no, and 19% weren't really sure. Now, when I say that this is kind of leveled off, it's because these percentages that we're looking at on this slide and on the previous slide are pretty similar to last year's percentages. So I'm not sure that we're seeing an increase there in terms of the percentage of employers that are dropping. Like, for example, you can see in 2025 in the gray box there, 62% said yes, more clients will drop marijuana in the next 12 months. This year, it dropped from 62% to 58%. Then when we asked the question, what effect will the rescheduling of marijuana on a Schedule 2 as a Schedule 3 controlled substance have on drug testing overall? It was kind of all across the board. But if you look at that orange bar there, 36% some, but not many employers will stop testing for marijuana. That was the number one response. 28% said many employers will stop testing for marijuana. I'm not really sure about that, because when you look at the other results of our survey, where such a large percentage, 78% said that they drug test because of safety and to improve safety in the workplace, and 84% believe that drug testing is helping them improve safety in their workplace. I think as long as rescheduling doesn't make drug testing illegal, which I'm 100% certain it will not have that effect, then I think most employers will continue testing for marijuana. So a lot of good information. You can dissect these in greater detail when you get the recording of today's presentation. But with that, let me turn it over to my associate here at the Current Consulting Group, Brian Feely.
Hey, thank you, Bill. I appreciate that very much. And thanks out to all the attendees for attending this webinar, and for Abbott for sponsoring it. And, just such great, valuable educational source of information that comes out in these. And even if you come away with a couple of good pieces of information, it was well worth attending. So, prior life, I've worked with Abbott and Abbott folks for many years with selling oral fluid drug testing, and just a, world-class organization with regard to their urine testing laboratory capabilities, oral fluid, instant oral fluid tests. So for those of you who utilize them, that. For those of you that don't, really great choice in terms of providers for you to be taking a look at. So I'm going to click here and see if I can advance my slide. I think the first one brings Jessica back in to run this poll, if you would, Jessica.
Absolutely. Thank you, Brian. So has your organization implemented oral fluid testing? And I'm going to go ahead and launch the poll while I read your options. Yes, we use it regularly. We are evaluating it. We plan to implement it within the next year. No, we currently rely on other testing methods. So I'll share these results. And so yes, we use oral fluid regularly, 41%. 8% are evaluating it, 4% plan to implement it within the next year, and 47% are currently relying on other testing methods. So I'm going to close this and send it back to you, Brian.
Okay, great. Thanks, Jessica. Interesting results. When you look at the overall percentages there, about 50, almost 50%, either utilizing it, considering utilizing it, or looking at it, versus less than 50% that are not using oral fluid today. Years ago, when we ran that kind of a poll, the numbers would be much less in terms of those percentages of people that are using oral fluid testing. So it just speaks to the overall trend and movement toward oral fluid. And so this slide, basically, I'm going to go through a couple things related to recent use and metabolite versus parent THC. We're going to talk a little bit about windows of detection and leverage off of some of the stuff that Bill had in his slides. So detection of oral fluid, really, of drugs in oral fluid, occurs very quickly. Oral fluid is really like a filtrate of your blood. So what comes from your bloodstream ends up through some major glands that are in the mouth, secreted and end up in that saliva or oral fluid sample. Literally, they went within minutes. But the publications out there support something like a 10 to 15-minute time frame from the time that someone used. And then they continue to stay in the oral fluid sample, depending upon which oral fluid you're using, lab-based or rapid, for a period of time out to a day or two. But with impairment, the impairment window is in that 3 to 10 hours that Bill talked about earlier, through a whole bunch of studies that have been done and really looked at the different effects that are on people from the use of marijuana. And so it aligns well with that 3 to 10 hour window, and is a good linkage to potential impairment. And if someone is doing a good job with their signs and symptoms and observing the things that are going on with an employee, and you have that well documented, and you combine it with a positive oral fluid drug test, you have a pretty good story that potential impairment was going on. It also says something about a positive drug screen on a pre-employment test. If someone can't abstain for long enough to not use marijuana for a day or two, what does that say about that candidate? So a good choice for pre-employment testing as well. So just kind of going through this window of detection, these charts a little bit more detailed. You see that you have on the left side breath, which is relatively limited in terms of its time frame for picking up marijuana. In fact, when it comes to drug testing, marijuana is the only thing that you could use for breath, and that's kind of in its infancy. But you have blood, which is not typically used for workplace drug testing, and then you have oral fluid and urine. If you look at oral fluid, the positivity starts coming up immediately after use and runs out for that window of detection of a day or two. But with urine, you're looking at a 4 to 6 hour lag time until a positive drug test would occur from someone using, because that has to metabolize and end up in the urine specimen as a metabolite. So there is a lag time. And of course, when you're looking at hair, it's way further out. You're looking at weeks to months. So, when you look at the chart to the right, it's really blowing up that low recent use detection window samples. Breath, again, only good for about 2 to 3 hours, very new, and just coming into its own. Oral fluid, though, picking up positive tests immediately and out to about through the 10-hour window of impairment. Urine missing some of that and only picking stuff up after about 6 to 8 hours. So it just kind of shows how that window of detection can be impacted by these different drug testing samples, and how important it is to know that and pick that when you're aligning it with the reasons that you're testing, whether it's pre-employment or post-accident or reasonable suspicion. And here we're talking more about potential impairment. You're talking about post-incident or accident reasonable suspicion type testing. Oral fluid, of course, is of those methods that were there, of the recent use tests. Oral fluid is the only one that's endorsed by the federal government right now, and where there are DOT guidelines as well, which we'll talk about in a second. So in case there was any sort of doubt about oral fluid, or it's new to you for some reason, it's been out a long time. So we launched oral fluid testing back, probably 28 years ago now. With the company that I worked for. But during that time, so there's been extensive studies of oral fluid and marijuana in oral fluid. Lots of reports, peer-reviewed publications, literally hundreds of them, that show the detection of marijuana in oral fluid, the ability to pick up that THC parent compound. There are some differences between lab-based and rapid. That's because the cutoffs are a little different for a rapid test versus a lab-based. With a lab-based test, you're typically able to pick up marijuana in an oral fluid sample for about a day. Some reports have shown out to 36 hours. With a rapid test, the cutoff is higher, which really is a good alignment with a workday kind of use. It's usually in that 6 to 10 hour time frame, which again aligns very well with what somebody could be doing on the job. So that's important. When you look at, what's the reason for some of the laws that are being changed, what could be, our world going as marijuana continues to get legalized and the rescheduling world, oral fluid really aligns very well with a continued legalization and potential for rescheduling. And the reason for that is there are two types of THC that's tested for. One of them is the metabolite, which is THC, the carboxylic acid form, for what it's worth. But that's a metabolite that gets formed in the body as a function of breaking down THC. It is a non-psychoactive form of the drug, and so that's what you're testing for typically in urine and in hair, unless you add on the parent compound, which typically increase the pricing. With the parent THC, also referred to as Delta 9, that's the psychoactive form of the drug, and that's what you find in oral fluid and breath, for that matter. We've seen several states, California and Washington, both establish laws over the last 2 years that basically limit employers' rights to use the metabolite-based test, because those marijuana is legal in both of those states, and you're really looking at past use, not current use. So really, in those states, oral fluid is the best solution because it's testing for the parent, the psychoactive form of the drug. It aligns with those state laws. We're now seeing some additional states considering language very much like that. So this is a good heads up for those of you not only that are in California or Washington, but also considering redoing your policy. A good reason to look at oral fluid for these kinds of reasons. So the DOT rule piggybacked off of the SAMHSA guidelines some years ago. SAMHSA came out with the oral fluid mandatory guidelines, which stated all the reasons why oral fluid was being added for federal testing. Once those SAMHSA guidelines were out, that basically gave DOT the information and the ruling they needed to establish their own rulemaking process, which they did several years ago. They came out with a ruling to allow for laboratory-based oral fluid drug testing in 2023. And for these reasons, all the sort of things that people, I think, should know about, at least for what oral fluid is associated with now. Combating adulteration and substitution, they're all directly observed, 100% directly observed. There's a cost savings that can be had depending upon how you do your oral fluid testing. Very quick and easy specimen collection process. There are fewer collection facility requirements if you do get it done at a facility. You get that shorter window of detection, picking up recent use. And so those are the reasons they stated. Now, although those guidelines, federal guidelines are out and DOT ruling is out, you cannot currently do regulated or DOT testing yet until 2 labs are certified, which we hope is going to occur sometime in 2026. There's some pretty good reason to point to that says that should be the case. My crystal ball says I'll wait till it happens, but right now that is a good possibility. So moving to the next slide. There we go. Okay, so the top advantages of oral fluid kind of summarizes a few of the things we've already said, maybe some things we haven't, but oral fluid does not require the use of a collection site or a bathroom. Often these things can be done at an employer's site by someone trained to do a simple oral fluid collection, and both an instant test and a lab-based collection can be done like that. It's less invasive, it's easy to collect. They're 100% directly observed, and if you know about urine testing, it's one of the kind of fallbacks that does happen. It is people go into a bathroom and things can happen in there, and they're not being fully observed. It's really hard to adulterate and can't be diluted either from the standpoint of substituting or diluting a sample. Oral fluid reveals recent use, as we've talked about. It's a little more union friendly if unions, would weigh in or like any kind of drug testing. We've heard in the past, as my team called on accounts, that they like it a little more because of that less invasiveness. It's a recent use test, so they're not picking up what somebody did a week ago or 2 weeks ago. It's gender friendly, so it doesn't matter, male, female collections can be done. And like I said before, it can reduce the cost of testing depending upon what you're actually doing. So last slide, just a couple of conclusions. Oop, I think I jumped one slide too quick. It's important to really review all the applicable state laws. Even case law can come into effect in certain states. The marijuana laws definitely come into effect, so that when you do update your policy, it really reflects all those legal requirements. Things are changing all the time. Bill mentioned the number of state laws that have been reviewed. We keep track of the laws that are introduced, the laws that fail, the laws that passed, and all that sort of stuff. And so we can be a source of information there. But really updating that policy, making sure you have all the information to do so. If you're going to add oral fluid to it, make sure that's the right laws have been considered, because it is different. Just like an instant test versus lab-based, there are different guidelines and statutes that relate to the type of test you can do. When you will do oral fluid testing, how the samples will be collected, and where and what employees will be subject to that test. All that stuff should be part of the policy update. And then, of course, informing your employees of the changes that are made to your policy, and making sure supervisors and managers are trained and they know how to utilize that tool. That policy tool is just so important in terms of being a guidepost for your company's program. And you know, the hiring, firing, and retention of employees is heavily based on what your policy says, and it needs to be up to date. So, you know, just to summarize, but not on the screen, oral fluid is really I think a good choice in this post rescheduling world, but not just post rescheduling, just post legalization, medical marijuana. It's aligning better with the state laws than the language that we're seeing. It's a good indicator and tie in with a potential impairment. And if you're doing the right signs and symptoms tracking and keeping that all, you know, tightly knit, it's just a really good way to go for all of that stuff. So I am gonna just advance, or I'll let you do that, Jessica, to the next slide, and then we can do Q&A.
All right, excellent. Thank you, Bill and Brian, both of you, for your expertise in this area. Again, thank you, Abbott, for having this webinar. We're going to spend the last 10 minutes doing a little Q&A. And so if you have questions for Brian and Bill, please feel free to use the questions section to send us those questions. And then Bill and Brian may have a couple questions for each other. So if they circumvent me and keep going, that's okay. I'm going to allow it. But let's start out with a question for Brian. Brian, do you see employers using oral fluid in addition to urine for post-accident and reasonable suspicion testing?
Yeah, most definitely. So we've seen it all over the years. When we first introduced oral fluid years ago, people would implement it for their overall program, and then, you know, which include pre-employment, for random, post-accident, everything, just because of the ease of collection and adoption. You know, sometimes it's easier to do all one and not mix and match. But I think more and more, as time has gone on and oral fluid has been introduced, other matrices have been introduced, people have looked at and you know, gained the information, like from this webinar, where you can see the value of mix and matching. It's not one size fits all anymore. So for so many years it was just urine, and now there's oral fluid, there's hair, you know, so people are doing a little bit of mix and match depending upon what they want to achieve for the program. If you're looking for a little longer term indicator on that pre-employment test, I want to go back a few weeks, then a urine pre-employment test makes good sense. If you really want to go back far, you know, a hair test can be used, although we see less of that, I think, overall in the market. Probably the majority of combination testing that I've seen has been a combination of urine and oral fluid, where urine is used for that pre-employment test, and oral fluid is used for, you know, post-incident, reasonable suspicion, for cause, and potentially even in a random program.
Okay, great. Thank you for that that information on that. Another question that came in, and this is probably for Bill, but whoever wants to take it, the question is, which state laws are to be followed if you have a driver based in state one, licensed in state two, and driving through state three? They really wanted to give you some options there, Bill.
Well, I couldn't help but laugh. So the answer to that question is, you know, tell us what states you're talking about, and if these are drivers that fall under the DOT regulations. Because if it's a driver that falls under the DOT regulations, then the state law becomes immaterial. You have to comply with the DOT regulations for testing that individual. So, but beside that, though, it would depend on what states we're talking about. It's a great question, and it's one of the reasons why we always, advise our customers to let us customize the policy to include different addendums for the various states that they're in. Because you may be headquartered in Texas, which is a very drug testing friendly state, but have operations also in, say, Maine or Vermont or Massachusetts, just to pick a few examples of states that are more restrictive when it comes to drug testing. And so your policy should reflect all the different laws that apply to you, but specifically in this instance, which is again a great question, depends on what states we're talking about. But I will say that if it's a DOT driver, then you have to comply with the DOT regulations.
Sure. And to follow up, if it's not a DOT driver, then even more so, would you recommend looking at those specific state laws?
Yeah, I need more information, but that it's a great
Absolutely.
question. But feel
Yeah.
free to email us and we'll research it for you and give you an answer.
Yeah, so we have your information. If you are submitting questions like this that are better answered offline, we will contact you offline to help you with that information. All right, another question that we have, um, what we're finding with oral fluid is individuals not cooperating in activating the device, so they will move to a urine test. The activation and amount of time to collect a sample to activate has become a topic for those individuals trying to manipulate the test. Has that been taken into consideration, and what to do in those situations? I don't know if this is for Brian or for Bill or for offline, but another one of what to do when they're trying to manipulate the test.
You want to take it, Brian?
Yeah, so I mean, this is no different than if somebody's trying to cheat on their urine test, right? They're trying to bring something in their pocket into the collection site or into the bathroom to cheat a test, or they're trying to say they can't urinate and they're waiting and waiting and waiting to give a sample beyond what's acceptable. If they're refusing and messing with the oral fluid collection process, that's considered a refusal to test and can be reprimanded and noted, and is subject to the same ramifications of drug testing, of a urine test that somebody would have in their policy, as long as again it's documented. And I'm assuming we're referring to a non-regulated type application. Put it in the policy, make sure it's clear. If it's in the DOT or a regulated employee, it's pretty clear about how you handle adulterated or attempts to adulterate or refuse to test. So no different, really.
Yeah, and let me add this, that, urine testing, of course, is still the king of the hill, so to speak, in the world of drug testing. It's the most, popular, common drug testing method. But as I mentioned earlier, from our annual surveys, we're seeing considerable growth in the percentage of not only providers that offer oral fluid testing, but employers that say they're using it or they're going to be adding it soon. So one interesting point there, I was preparing for a webinar I was doing a few years ago on how to drug test cheating. I won't say how to drug test cheat, but how people cheat on drug tests. And I was doing research on both urine and oral fluid testing. I actually included hair testing in it as well. And it was interesting, on this one very popular, commonly used website that sells products to help people cheat on drug tests. When it came to oral fluid testing, they said the best advice we can give you is stop using drugs if you want to pass an oral fluid test. So I thought that was interesting and humorous.
Absolutely. Thank you for that, Bill, and from you, Brian. We do have a couple more questions coming in. One question asks, on the DOT form, there is an oral fluid section. Will this be to fast track the use once marijuana gets rescheduled?
Well, Brian already, covered it very well that we're not to the point yet where employers can use oral fluid testing in compliance with the DOT regulations, but the entire industry and DOT are gearing up for it. So we're we're hopeful and optimistic that it's going to happen soon. And as you can see, we're getting ready in lots of different ways for that to actually be usable.
Yeah, and Bill, just
Excellent.
to add in case there's any confusion there. So the addition of oral fluid to DOT and the two labs getting certified to be able to offer oral fluid, laboratory-based oral fluid drug testing has no tie-in with rescheduling of marijuana. That's a totally separate issue. So really, what you're seeing on the forms is sort of a anticipation of those labs being certified and being able to begin doing oral fluid testing regardless of rescheduling.
Yeah, and it's important also to add that outside of the DOT regulations, employers have been using oral fluid testing, both lab-based and point of collection, for many years. That's where we're seeing the growth is perhaps because DOT has endorsed it, if you will, even though it's not usable yet for DOT compliance. But we've been seeing that percentage of employers that say they're using oral fluid testing either in addition to urine testing or in place of urine testing. We've been seeing that percentage going up over the last probably 5, 6 years now.
Great, thank you for that. So we are actually coming up at the top of to the top of the hour, and because we know that we all have busy schedules, we don't want to keep you longer. And so if you have submitted a question that was not answered, we have a few that have just been coming in here at the last little bit. We'll answer your questions offline and make sure that you have answers to those questions. If you have any questions for today's presenters that you think of later, please feel free to submit them. Reach out to us. You can also reach out to our friends at Abbott at marketing@escreen.com for more information about their services. And then not obviously, it's not on the screen. You can reach out to Current Consulting Group at info@currentconsultinggroup.com if your questions are more related to the content of today's presentation. We'd like to, again, thank Abbott for sponsoring today's webinar presentation. We recognize that their brand offering is trusted and is a company that you can turn to for support in the business that you do. Um, we also wanted to remind you that today's presentation qualified for continuing education credits and that we will be sending information to those who have attended the entire live webinar presentation. And we also will send you a link to the recording of today's webinar presentation so that you can review this information again or share it with your colleagues. And so again, we'd like to thank Brian and Bill for their time and Abbott for their sponsorship. And that concludes today's webinar presentation. We hope you all have a great day.